Five, Justices of the Appellate Division, Supreme Court, First Department. We hear you, all persons having business with the Appellate Division. You are here, your attendance shall be heard. Please be seated.
Welcome to the Appellate Division, First Department. We have almost 6.5 hours of argument today requested, so only ask for the time you need. We have reviewed your briefs and records and are familiar with the case. First case is People versus Sebastian Benjamin, appellant.
Appellant requests 7 minutes and 2 minutes for rebuttal.
I'm going to give you 5 and 1 and 5. Muco versus Board of Education, appellant.
Appellant, Your Honor, 7 minutes and 2 for rebuttal.
I'll give you 6 and 1 and 5. King, appellant. Is respondent here? Okay, it's submitted. People versus Prince is submitted. Pizzarati versus Extreme Concrete, appellant. Respondent? 5, 2, and 5. Sue versus Chow, appellant.
5 and 2, Your Honor.
I'm sorry.
5 minutes and 2.
Respondent?
5 minutes.
5 and 1 and 5. Amber Capital versus Farrell, appellant.
Appellant, Your Honor, 10 and 2.
Respondent?
5 and 7.
5 and 1 and 5. People versus Kelvin Johnson, appellant. Respondent? Submitted. Harpaz versus Dunn, appellant.
Appellant, 5 and 1.
Respondent, 5, 1, and 5. 9 Orchard Partners versus New York City Department of Finance, appellant.
5 and 1, Your Honor.
I'm sorry, 5 and 1?
Yes.
Respond?
Respondent requests
5, 1, and 5. International Financial versus Hambrecht, appellant.
Appellant respectfully requests 7 and 2, Your Honor.
Respondent?
Respondent requests 5, please, Your Honor.
5, 1, and 5.
Thank you.
People versus David Williams. 5, 1, and 5. Haskin versus New York State Division of Housing, appellant. Respondent? Is respondent here in Haskins? Do you wish to submit? Your opponent isn't here. Do you wish to submit? I would like to speak briefly. Okay, I'll give you 3 minutes. Liberty Mutual versus Old Republic. I'm not sure if I have the order right, but appellant?
Yes, Your Honor. 8 and 2.
Respondent Travelers?
Yes, Your Honor. 4.
Old Republic?
Old Republic, 4.
And PLIC?
PCIC, Your Honor.
I'm sorry, I got it wrong.
4, please.
Okay, I'll give 5 and 1 to appellant and 4 to each of the respondents. Quipu versus Weissman. Has the appellant arrived? Is the respondent here? Okay, I know there's been a phone call from the appellant, so for now, I'll put it down for 4 and 1 and 4, and if they don't show up, we'll just mark it submitted. Aristocrat Plastic Surgery versus Silva. Appellant? Respondent? 3, 2, and 5. Okay, the first case is People versus Benjamin.
May it please the court, Joseph Nursey representing Sebastian Benjamin. There was no evidence at all that Sebastian Benjamin had ever engaged in any gang activity at any time. Indeed, there was no evidence that he had ever engaged in any criminal activity at all. He had no prior record, no arrests, no conviction, no juvenile record, nothing. Nonetheless, based on a photograph where he is seen holding his hand like this, the Detective Green testified that that was the gang sign for the Lyman Street gang, and based on nothing more than that, the prosecution was permitted to call him a gang member at trial. Detective Green testified that he was a gang member at trial, and the prosecution was allowed to argue to the jury that the homicide in this case was a part of an ongoing series of criminal activities by the Lyman Street and Vice Avenue gangs going back to 2008 that involved shootings and slashing and other
So
criminal...
wasn't there overwhelming evidence of guilt in this case, separate apart from any of the evidence about the gang-related activity?
No, Your
Based
Honor.
on the surveillance and the confession, both of which showed him as being the shooter, and he confessed to being the shooter.
Okay, Your Honor, the answer is no, there's not overwhelming evidence. This is why. The jury acquitted him of most of the charges. They acquitted him of conspiracy. They acquitted him of second-degree murder. Also, in his...
But even with what you're saying, that doesn't undercut that he confessed and the surveillance shows him. So even if he was not part of a conspiracy, the evidence shows that he was the one who did the shooting and he admitted to doing the shooting.
He did not admit to shooting Mr. Pagan. He admitted to firing a gun. In his videotaped statement, he stated that he shot one shot up and away, and he demonstrated on the video showing shooting it up and away. Now, normally that might be considered just a self-serving statement, but the the crime scene unit person, Detective Guilford, at the crime scene did in fact find a gunshot hole in the side of a building up and to the right of where Mr. Pagan was shot, 11 feet above the ground. And it was always the prosecution's position in this case that the co-defendant, Jermaine Johnson, fired a shot in this case. And you have the 911 recording and the two statements of the police made by the eyewitness, Pedro Harrison, who was standing right next to Mr. Pagan when Mr. Pagan was shot. And he chased after the person he said fired the shot, the shooter. And on the 911 call, 3 times he describes Jermaine Johnson as the person who did the shooting. In the statement he made to the police right after the shooting, he described Jermaine Johnson as the shooter.
Let me go back
Counsel,
to go ahead.
getting back to the issue of the gang activity,
Yes.
didn't the trial court issue a limiting instruction, which the jury was free to, what followed, and is reflected in their verdict?
A limiting instruction is only meaningful if the evidence was properly admitted in the first place. In this case, under this court's decision in Singleton and Pagan and other cases, it was never properly admitted in the first place. So telling them they could only use it for a limited purpose to determine motive is meaningless because they never should have heard it at all. There was no evidence anywhere that he had ever engaged in gang activity. I think it's important that at the hearing on the admissibility of the gang evidence, at page 45 of that hearing, the co-defendant's attorney asked Detective Green if being in a photograph with gang members makes you a gang member. And Detective Green responded, no. And these are his words, quote, "It's not association that makes them a gang. It's the acts of crime that they commit that makes them a gang." There was no evidence that Sebastian Benjamin had ever committed any crime, much less any gang activity, prior to the homicide charged in this case. The evidence of all this gang activity, this evidence is of shootings and slashings dating back to 2008, never should have been admitted in this case.
Thank you very much. You'll have time for rebuttal.
May it please the court, Matthew White for the people. The evidence of guilt was in fact overwhelming. Defendant was on video. firing into a crowd of unsuspecting people. That is not contested. The claim that he somehow raised his hand at the last minute is actually belied by the video statement itself. And I would direct the court's attention to that video statement. He says repeatedly that he fired at the crowd and that it was his plan to go to Vice Avenue and shoot at the people who had allegedly threatened him before. And
Counsel, in light of the defendant's statement, why do you need the gang information for? What usefulness did that provide?
so the defendant's statement was in some ways misleading and contradicted by the physical evidence and by the video evidence. For example, the defendant stated that he only fired one time, and he does not mention anyone else firing shots. However, we know at least 2 to 5 shots were in fact fired. The defendant also does not mention the role that his co-defendants played in this case. Co-defendant Jermaine Johnson accompanied the defendant across the street and is seen on video also appearing to shoot. Defendant says that that co-defendant actually tried to get him not to go to Vice Avenue, right? And then there was a second co-defendant, Martinez, who was the lookout. And defendant's statement utterly fails to mention him. And so the statement alone would have been misleading to the jury because it did not explain why, in fact, defendant and the 2 co-defendants went to Vice Avenue and engaged in essentially an ambush on an unsuspecting crowd, complete with a lookout and 2 people firing weapons.
You don't have to be part of a gang to ambush someone, do you?
You do not, but the evidence was admitted to show motive and to show acting in concert. And defendant's statement,
Aside from the 2 photographs, what evidence do you have that the defendant was part of this gang?
so there's a photograph of the defendant flashing the gang sign. There's a photograph, 2 photographs of him with the co-defendants when the co-defendants are flashing the gang sign. The defendant was in fact known to the police department because the defendant had been questioned in connection with a 2011 homicide. The defendant was recognized by another police officer from the surveillance video, so the defendant was known to the police. The defendant made a call from Rikers Island to another member of the Lyman gang in which he indicated that he was having a problem with another gang in Rikers. And again, defendant's
Is there any evidence that the defendant committed any acts, any crimes, anything at all that would be indicative of belonging to a gang?
Yes, Your Honor. So defendant's statements to the police, he claimed he was threatened, right? And that's why he got a gun. And he claims he got the gun and he stashed it in and around the area at Lyman Place, which is where the gang operated from. So he says he got the gun. So that precedes the homicide, right? And then he goes to Vice Avenue. And the only reason it makes sense for him to go to Vice Avenue is because it's a gang conflict. And that's what he indicates without saying as much in his video statement. He says he was threatened. And even though he doesn't recognize the people, he just assumes they're from Vice. He just assumes they're from Vice Avenue. And the gang evidence is the only reason that makes sense. That's the only reason for him to go there. Excuse me, it's hard to talk with the mask. And again, there was overwhelming evidence of the defendant's guilt. There was a limiting instruction, and any error would have been harmless in the admission of this evidence, but the court acted within its discretion.
Thank you very much.
Thank you.
In order to convict Sebastian Benjamin of first-degree manslaughter, the jury would have had to have found that he intended to inflict serious physical injury. In his statement, he said that he did not intend to shoot anyone. He stated that he shot the gun up and away, and the physical evidence at the scene of the bullet hole in the side of the building is consistent with that. Now, the jury didn't have to accept that, but the jury should have been able to look at
In
this.
his video statement, isn't it accurate to say that the defendant, he indicated that he was pointing the gun forward, and then he sort of turned his head or closed his eyes when he shot, and he indicated that he closed his eyes as he shot. Isn't that really what was said in the video statement?
Yeah, yes, and then he was asked to physically demonstrate it, and he shows shooting up and away, and that's where a bullet hole ended up. I mean, again, The jury didn't have to accept that, but they should have been able to consider that without all this prejudice of gang evidence. And if you look at Detective Green's testimony throughout both the hearing and the trial, he repeatedly said that Sebastian Benjamin was never known to him as a gang member. He was not on their radar. He was not in the gang YouTube videos.
Thank you very much. The next case is Muco versus Board of Education.
Good afternoon, Your Honors. James Strauss for defendants' appellants. We're here on Mr. Muco's claim, labor law violations, when he fell in an interior staircase on a stair tower attached to a public school in Bronx, New York. There was a roof project going on. A stair tower was erected next to the building so that the employees could go up and down externally rather than go through the building. Mr. Muco claims that he was descending stairs within the staircase. Somehow the stair tower, he claims, moved in some fashion. He claims that he lost his balance, reached out for a handrail, and there was no handrail, and therefore he fell and injured himself. He commenced a labor law violation complaint against us, Section 200, 240, 241-6. The real heart of our argument here is that Justice Suarez erred by granting the 240 claim in Mr. Muco's favor.
Is your argument that 240 summary judgment was inappropriate because you have submitted contradictory testimony showing that there was handrails and that the scaffold was stable and secure?
Absolutely correct, Your Honor. We had a very intense investigation, literally moments after the accident occurred. We are challenging Mr. Muco's how the accident occurred and his credibility.
What's the significance of the fact that no one was present other than the plaintiff when the accident occurred?
There's no significance to that because we're challenging both the manner in which the accident occurred and his credibility. His credibility in particular with respect to the handrails is very important here because, first of all, the stair tower itself is a safety device. And within that safety device are handrails. And Mr. Muco says he reached out for handrails, but before Justice Suarez, we produced photographs and 4 affidavits, all of which said handrails were present throughout the entire.
Counsel, isn't it right that some of the photographs that were produced didn't actually depict the area where he fell?
Well, actually, that's what plaintiff contests. We don't contest that. We claim that we got the right spot. But either way, it creates a question of fact. And speaking of the handrails, plaintiffs themselves concede that there's a question of fact on the handrails. One of our arguments here is that our 241-6 claim should have been granted in our favor because there are 3 industrial code sections that are at issue. 2 are handrails, one is lighting.
As to the 241-6, if your argument that there's a disputed issue of fact as to whether there are handrails, wouldn't that support a 241-6 claim that you're not entitled to summary judgment on it?
I hear you. If you conclude that handrails were on the stair tower, which we say there were, then those industrial code violations go. The lighting as well.
Isn't the only real argument that there's an issue of fact about it, since the plaintiff is testifying that handrails were missing, your witnesses are testifying that all the handrails were present. Isn't that a classic disputed issue of fact?
It is. In this case, it is. I'm just saying if you had agreed.
So how would you get summary judgment on a 241-6?
Well, you can look at the photographs and decide that as a matter of fact, they were present.
I know, but then we get back to the point that he said, these photographs don't depict where I fell.
That's what he says, but regardless.
That's an issue of fact, counsel.
Plaintiff concede, okay, let's say it's a question of fact. But the point of it being a question of fact is if it's a question of fact in the 241-6 aspect, it's also a question of fact on the 240 aspect. And the 240 aspect shouldn't have been granted either because there's questions of fact based on disputed testimony as to how the accident occurred.
What about the reasoning of the court below that even if there were no handrails missing and it was secure, the fact they fell off the ladder is enough or the scaffold is enough by itself to grant
Well,
judgment?
first of all, we contest how he fell because we don't believe that the stair tower could have moved, and that's what our testimony shows. That's why we're contesting the manner of his fall in addition to the credibility of his statements. But with respect to the fact that he fell, it's well established in New York law, certainly under O'Brien and several other Court of Appeals cases that we cite, that just because somebody falls in a 240 case that doesn't mean that a 240 violation has occurred. Here, Justice Suarez totally ignored all the affidavits that we submitted, the evidence, the photographs that we submitted, and found that just because he said he fell, that was enough for him, and therefore a 240 violation should occur. Why can't a jury hear our testimony? Why can't a jury hear our investigation? Why can't a jury hear our unrefuted expert witness? In O'Brien, the court talked about there were competing expert affidavits, and there was a question of fact as a result. Here, where is plaintiff's affidavit contesting our expert witness testimony? Where is there any evidence that challenges that the stairway tower was not safe and secure and bound to the wall the way our expert testified? There's nothing. We have 4 lay witnesses, 1 expert witness, but there's no competing evidence. At least in O'Brien, there were competing affidavits of experts. Here, we are the only one with an affidavit from an expert that talks about it. So for all these reasons, we believe that the 240 claim was improperly granted. I'm not asking for summary judgment on 240. I'm just saying, let it go to the jury. Why can't the jury hear what we investigated? Why can't the jury hear our expert and evaluate Mr. Muco's credibility, particularly with his statement that there were no handrails, where we produced pictures of there being handrails?
Okay, so let's hear from respondent.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. Let me tell you why there's...
Why don't you give your response to that? Why shouldn't summary judgment have been denied on the ground that there are conflicting versions of what caused this accident? Your client clearly made a prima facie saying handrails were missing, the ladder was unsecure, but then there was abundant evidence on the other side saying, including people who saw the scaffold immediately after the accident, who said, you know, the handrails were all there and the scaffold was perfectly secured.
Look, that's what I'd like to address first, if I can, Judge Kern. There is no contrary evidence with respect to the fact that this stairway scaffold moved. Let me tell you why. They were very, very clever. They did something very, very smart. They took our proof, and then they got 5, 6, 7 affidavits. Their expert affidavit is irrelevant because it's 5 months after the accident. But what they said, you have to look at the words. There isn't one iota of proof in this record anywhere that anyone actually tested that stairway scaffold to see that it was stable. Let me tell you the words they used.
What about Khan looked at the staircase on the 19th of December and said, I think, I'll have to look at it again, but there was no movement.
The report that they're relying on specifically says that it was a visual inspection. And what every one of their experts said was that they didn't, let me give you the words, so you can take a look at each one. We did not observe the scaffold shake. Nobody said you have to observe it. If you want to say that something's stable, when the plaintiff establishes a prima facie case that it moved, because the movement of the scaffold establishes a violation of the statute under Blake, somebody's just got to pull it. So all they had to do, all of these witnesses who came after the scene, the only thing they had to do to establish a prima facie case was very simply to pull it and say, I pulled it and I saw it was stable. Not one of them said it. The words that they used was, I didn't observe it.
But observe can mean using all your 5 senses, I guess, can't it? I mean,
don't
does
think
it only
so.
mean the visual sense?
They said observed. I'm using their words.
No, I know, but observe, you can, I don't know. I'll look at the dictionary for that question. So
all I'm saying is, if you observe, they didn't say they tested it. They didn't say they felt it. They didn't say they shook it. They said, I observed it. I never claimed, and my claim was never, and still isn't, that this scaffold was habitually bad, and you're not going to be able to observe a scaffold shake if nobody's on it. The testimony of the plaintiff that the scaffold moved, the testimony of his coworker that it was shaky is not disputed, and they had every ability to do that. And Judge Moulton, if I can, if you take a look at the report of JNN Construction, which they rely so highly on in 535, JNN Construction says, and I'm quoting now, please note, this is a visual inspection and no other test was performed. So I'm actually relying on the methodology that their expert used in terms of saying they didn't establish a defense to my claim. One other thing, we know from the daily logs themselves, which are from 1215 to 1221, that this was a scaffold that was under complete construction. They were moving it. They were doing things with it. They were putting tie-ins. They were correcting defects. So plaintiff's theory of liability isn't out of this world. It's actually congruent with the very daily logs upon which the defendants rely. So my position is simple. All they had to do with any of these 6 witnesses was have one of them, just one, say, I pushed it 5 minutes after, I pushed it 30 minutes after, I touched it 3 minutes after, maybe there's a question of fact. But each one of them saying, I observed it without touching it, where their very own expert report disclaims any responsibility because it was only a visual inspection, my position is I win, and the trial court was correct in doing it. Thanks for listening to me.
Thank you very much.
Counsel, can you address your adversary's point? Is this a situation where your witnesses just looked at it and said it didn't move? Or did they do something? Did they test it? Did they move it? What happened?
My understanding, Your Honor, is that they went to first of all, they were there moments after the accident, of course. They looked at all the footings, they looked at all the bindings, they made sure that it was secure, they testified it was absolutely secure. That's what each one of them say.
Yeah, but that's a conclusion. How do we get there? How do we know that it was secured?
Well, all I could point you to is the affidavit, which is what they put in, that they came in and they investigated and inspected the scaffold. Their inspection may have been physical, it may not have been. I don't know that it had to be physical necessarily.
Well, if there's an ambiguity as to how those individuals arrived at their conclusion that the scaffold, if you will, the apparatus was stable, if there is such an ambiguity, is that sufficient to raise a triable issue of fact?
Absolutely. They could be asked that question at trial, and that exact argument could be made to them and say, did you actually touch the scaffold, the stairway tower? Certainly, based on the testimony presented in their affidavits, it raises a question of fact. And that's exactly what a jury can do. They can weigh the credibility of our witnesses. They can say, hey, you can be challenged on that affidavit at a trial, and the jury can decide if indeed they feel that that inspection that was made was inadequate. They'll rule in plaintiff's favor. But certainly there's enough questions of fact in this record
Thank you very
for the
much.
240 to be reversed. Thank you, Your Honor.
Israti versus Extreme Concrete.
Good afternoon again, Your Honors.
Welcome back.
Thank you. I'm on the other side this time. It's a little bit of a different case. Judge Kern, to try to get this moving, because I know you have a big calendar, I think there are 3 basic issues here. I'd like to discuss them briefly, answer any question, I'll sit
I'm going
down.
to ask you to actually focus on, in particular, the waiver and lien provision.
Yes.
And what impact that has on the breach of contract, because it is an unusually broad release, broader than in many of the other cases. So, and there are cases that say, if you can show some conduct after the date of the waiver, which shows that you weren't really intending to enforce it, that could create an ambiguity, an issue of fact. So what conduct is there that you're pointing to in this case, after the last waiver and release was signed, that supports your argument that it should not be enforced according to its very unambiguous terms?
Yes, so let me deal with that directly, because my answer is, if you look at page 29 of the record, you see that the waiver of lien or the acknowledgement provision in 4.2 makes reference to a specific exhibit on 187, which is called the subcontractor's partial waiver and release. If you look at pages 248 to 260, you'll see something that I quite frankly can't explain. I don't think there is any explanation for it. 3 of those partial releases comport with Exhibit I. 5 don't. They have added clauses in them which are not part of the exhibit. So the contract itself required the execution of a particular partial release. 3 of those were then done. 5 weren't done. I'm assuming they were unilaterally changed by the plaintiff. That alone creates a question of fact, because the contract says one thing, and the releases that came in say another thing. This is a summary judgment motion. I'm not saying it's a 240 sub 1 case, pardon my reference to the other case, but all I'm saying is you don't get summary judgment where the contract itself has ambiguities in it based upon the party's conduct. Also, with regard to the...
So I'm trying to follow this argument. What are you saying those 5 do say, that they don't have release language?
They do not. 248, 249, 250, 248, 249, and 250. 251 has it. 253 to 254 has it. 255 to 256 has it. 257 to 258 has it.
Does the last one have it?
Last one has it too, sure.
And does the last one cover all of them?
No, my position is it doesn't, because you can't unilaterally change those documents. That's the question of fact. Look,
But doesn't the last one say that it covers all work up till that date?
the last 5 say it covers work up to that date, but the contract itself has a separate provision on this 4.4 for final payment, which this doesn't even have. That's the point. It's not that they don't have an argument to make.
But if it's not, there's a distinction between a release as to final payment versus a release as to the work that's been done up to that date, because there could have been more work done after that date under different circumstances.
Well, we got thrown off. As soon as we...
Right, but to say it's a release up to date versus a final payment, it wasn't a final payment except for the fact that you got thrown off.
Right, but they're using
So
it
why
as...
shouldn't, based on the language of the last release, it be a release for all work up to that date?
Because that last release didn't comport under the decisional law that we cited, the Security Mutual case specifically, which is the lead First Department case, with what happened and the party's course of conduct. Remember?
Why not?
Because this was a case where my client was supposed to be paid biweekly, tried to walk off the job twice.
But didn't every time a requisition come through, it got paid in full? There's no dispute on this record. There were 8 requisitions, and all of those requisitions were paid in full, that all of the requisitions up to the date that the work stopped being performed were paid in full, and that there was then a waiver from your client of all the work up to date.
But that's the point. In other words, the cases talk about these clauses being, as opposed to a general release that releases all claims, a partial release that acts as a receipt. And that's exactly what my client thought.
In those cases you're referring to, there was clearly conduct occurring after the waiver which supported an ambiguity. Like, for example, one of the main cases, there are actually payments made for that work after the fact, and there were not full payments made for each requisition. So in that case, there was clearly conduct creating ambiguity. So that is my question to you. After the date of the last payment, which was not a final payment because more work could have been done, what conduct was there on the part of the plaintiff that supports a waiver?
There was none because we were thrown off. But my argument isn't that. My argument is that you can't use... May I just finish answering your question? I'm sorry. My argument is you can't use an inappropriate clause that's contrary to the contract to throw in a release that is not congruent with the party's conduct, is not congruent with how they were paid, and isn't congruent with the very contract itself, even most importantly.
Thank you very much.
Thanks.
May it please the court, my name is Pooja Sharma, and I'm appearing from Picard and Abramson on behalf of plaintiff respondent Pete Cerroti.
What's your response to his specific argument that not all the waivers were the same, and that you're going to look at the actual waivers, 5 of them were different than 3 of them, and what impact should that have on the claim?
That should have no impact, Your Honor. If you take a look at the provision counsel cited on page 29, it says that the lien waivers shall substantially comport with the one in Exhibit I. So substantially comport doesn't mean it has to be verbatim the same form. And counsel in the motion papers below actually conceded that there was no difference between the former lien waivers and the form that they changed into. And that is on page 736 of the record at footnote 1. So the fact remains, as Your Honor correctly noted, that these waivers were executed after the last damages that they've been claiming. They claimed damages from conduct in January, August, and December of 2016. The last waiver was executed in February of 2017. They did not carve out an exception for any of these claims. And the release language itself is not ambiguous. It's very clear. It says on page 259 through 260, Extreme further understands and agrees that this waiver of lien and release is neither a receipt for payment nor a condition precedent to payment, but a knowing and willful acknowledgement that Extreme has been fully paid for all work, labor, and materials or equipment provided by Extreme, its subcontractors, and suppliers through the above referenced date in accordance with this waiver of lien and release.
Is that language in Exhibit I too?
No, Your Honor,
That's a difference right there that Mr. Isaac highlighted, was that 3 of the waivers don't have that language. And also the contract template, Exhibit I, doesn't have that language.
That is correct, but
That's not, I mean, they're not substantially the same as you just quoted from the contract, from page 29, from record page 29.
I would argue that it is substantially the same, and even counsel conceded in its papers below that the release, that there is no difference between these 2 release forms. I think that shows that the purpose of the release, which is to waive the claims for the time period set forth in that requisition, is preserved in both forms of the release.
If that language wasn't there, wouldn't you be subject to the case law that Mr. Isaac was referring to, where in this context, we treat the waiver as just a receipt of payment as opposed to a bona fide waiver and release in its classic sense?
No, Your Honor, because the Extreme had plenty of opportunity to review the new form of releases, to object if they so chose. And even if you look at the subcontract in the record, starting at page 26, there are significant amount of handwritten changes all over the contract. So this is a sophisticated business entity who is well aware of the nature of the construction industry and is capable and has shown willing to mark up a contract document when it so suits its purpose. So the language in the release may have changed, but it still clearly shows that these claims were fully released at that time.
And how many of the 8 releases contain that language?
5, Your Honor.
5 of the?
Anything else?
The other thing that the court below correctly decided was that these claims are all delay claims, and there's a broad no damage for delay clause in the contract that bars these exact sort of claims. So on these 2 bases, there's no
They're also
valid...
claiming for the unpaid contract price, right? So there's not all delay claims that they're seeking.
No, in the verified statement of lien, all the claims that they're seeking are related to delays. Most of them are, related to changes from the design team that was hired by the owner, not Pizzarotti. So we are not responsible for that conduct.
The unpaid delayed claims came to roughly $3,312,000. That's not a delay. I thought they did break it out. They didn't break it out? They certainly break it out in their brief.
I'm sorry, my understanding was that the claims were all delayed claims, but the contract, I think it's delay claims and change orders that are disputed.
Okay, thank you very much.
Thank you, Your Honor.
Briefly, Judge Moulton, we did break it out. 319 of the record, you're 100% right. The $3,312,348 was predicated upon the fact that although we wanted to work, we couldn't work because none of our change orders got processed. And we had to pay insurance, we had to pay people, we had to pay expenses. Those are actual expenses. And that's right on 319 broken out mathematically. Your Honors, I thought I heard my adversary say that under point 4.2, the partial waivers and releases are okay because the clause says that they have to be substantially similar. I'm going to make one argument and I'm going to sit down. If you can tell me how the first 3 waivers that we signed, which contain absolutely zero, and I mean zero general release language, is substantially similar to the other 5, which not only contain that language, but, Your Honors, they put it in bold. In bold, it's in caps, 252, 254, 256, and 258. That is not substantially similar. I might not be as smart as a lot of people here, but I know what substantially similar
Sir, so
means.
let's assume that you're right, that they're not substantially similar. The breaches occurred at those moments, right, that the releases were proffered, and yet the parties continued along on their course of conduct. No one, Extreme didn't declare a breach.
Correct. But if I can, Judge Higgett, I think that supports my point. My client's position is, I wanted to walk off the job. I didn't do it because I had assurances I was going to be paid. He even has emails from the plaintiff showing that they were going to pay these damages. And then, because of a slippage of the general release language in one of these partial releases, he forewent all those claims. That doesn't make any sense. No businessman would do that. Nobody who acted in this way would do that. That's just not smart. And that's why there's a question of fact. Again, I'm not saying I win. All I'm saying is I don't lose summarily.
Thank you very much.
Thanks for listening to me.
The next case is Sue versus Chow.
Good afternoon. May it please the court. Bruce H. Letterman for the appellants. Very simply, two wrongs don't make a right. Here, the lower court determined, and we're not challenging, that the elections for the board of a small Chinatown condominium had not been properly conducted for a number of years. However, the lower court, in addition to ordering a new properly held election, decreed that at the new election and for the next 6 years, only 2 members of the Chu family, even though there are 4 who own units, may sit on a board of 6 people. In other words, the lower court's decision effectively decided that the anti-Chu faction of the condominium community necessarily, for 7 years, would hold 4 of 6
Counsel,
seats.
isn't the limit of 2 places on the board consistent with the express language of the plan and the bylaws, which so provide that they will give up control, and that the way to effectuate that is by only letting them have 2 seats on the board on an ongoing basis?
Control provisions in condominium plans have been historically always interpreted as having a majority. So control would mean more than 3 seats, 4 seats. So historically and by practice in the condominium community, the Chus could hold 3 seats. They wouldn't have a majority. They wouldn't have control. The Business Corporation Law, Section 619, which is captioned Powers of the Supreme Court Respecting Elections, has never been interpreted to allow a court to preordain the outcome of an election on application of an aggrieved shareholder separate from what the...
How does this preordain the outcome? Because they're not telling them how they should vote the shares. They're just saying that they can't vote for themselves, but they can otherwise feel free to vote for whoever they want. So how does it preordain the election?
If, and we believe this may be likely in the future, in 7 years, if the condominium community decides they'd like 3 members of the Chu family on the board, and they win those seats, they cannot serve. The whole point of this is that Judge Cohn, who I have utter respect for, determined that no matter what the condominium community decides, only 2 seats can be held. Consistent with the plan, which everybody bought under, it's possible, and we believe it should be the result, that 3 should hold. My clients can't vote their shares to take more than, or actually really Catherine Chu was the sponsor, can't vote her shares to take more than 3 seats. I see my
Isn't the purpose also to make common cause perhaps with other condo owners, rather than rely on her family members to provide, perhaps not a majority, but a block on the board?
Well, that's possible, but it's a relatively small condominium community, and there were 4 Chu family members who could be voted, who can vote. Only one is the sponsor, subject to limitation. It's a small board, and there's nothing wrong with that. I'd like to quickly just address there's a question of mootness that has been raised as to the Martin Act issue. It's not moot because in the future, Mrs. Chu, Catherine Chu, might decide to sell units. She might amend the plan. She has 4 units to sell. She might sell 2, and then she might decide to rent them. And under the court's decision, She's under an ongoing obligation to amend the plan, which is simply not the law. This court in the Bauer versus Beekman case, which I actually argued here 12 years ago, said there's nothing wrong with the sponsor renting units and allowing the plan to go stale. I'd like to conclude by stressing that my clients have perfected this appeal at fairly significant expense with a 7-volume record following trial, because they profoundly believe that elections should be fair. In the future,
Isn't that belied by their conduct in the last decade?
my clients respectfully, there are language issues. My clients believe they ran the project economically. Perhaps Mr. Chu ran it with a bit of an iron fist, but he believes it's been run fairly. The last election was conducted fairly. It was actually conducted under the supervision of Judge Peter Tom, formerly of this court.
Right, but that was thanks to Judge Cohen that happened, right?
Yeah. And as I said, we are not challenging that that a new election should not have been ordered. This is simply a question of remedy.
Thank you. You'll have rebuttal time.
Okay.
Good afternoon, Your Honors. May it please the Court. Brian Cohen, Lackman Cohen, PC, for plaintiffs' respondents.
What's your response to the argument that control, even if they had 3, they wouldn't have control of the board?
Sure. So that's based on the trial court's findings that over the course of many years, that when the Chus held 3 out of 6 seats, it was deadlocked, and they, in fact, maintained control. And that's based on their conduct. I understand that mathematically 3 out of 6 is not a majority, but the findings were extensive that when the Chus had 3 seats, they were in complete control.
Counsel,
If they didn't want to hold, I'm sorry, Your Honor.
Counsel, was there any weight that the trial court gave to the mismanagement of this property by the management company owned by Robert Chu? Was that anything that was considered in determining that the Chus dominated the board and didn't necessarily act properly in their best fiduciary interest?
Well, the court did make certain findings regarding how they were managing the condominium, but those also included the fact that they did not recuse themselves in voting to hire themselves to manage the condominium, that they engaged in countless self-dealing transactions over the course of many years that they were only able to do when they had 3 out of 6 seats. Nothing could as Judge Cohen held, nothing could happen without the Chus. If they didn't want to hold elections or meetings and they didn't show up, no meeting or election would happen. If there was a meeting and they didn't like what they were hearing, they would get up and walk out, and that was it. It was over. So while, again, I appreciate that 3 out of 6 is not a mathematical majority, in this particular situation, as was found over the course of many years, the Chus holding 3 out of 6 seats gave them control, which is what led to the mismanagement, the self-dealing, the lack of financial transparency.
Did Justice Cohen have the authority under BCL 619 to issue or craft the remedy that he did?
So BCL 619 enabled Judge Cohen to order a new election. The remedy, which was the temporary limitation of 2 out of 6 seats for the Chus, was based on the Supreme Court's broad equitable powers to fashion a remedy that is appropriate for the exigencies of this particular case. And we cite those in our brief, beginning at page 13. There's no need in situations like this where the court is exercising its broad equitable powers to fashion an appropriate remedy for there to be precedent. It's not necessary. What matters is the court has to do what it believes will be appropriate based on the facts of this case. And here, Judge Cohen found that over the course of many years, that when the Chus had 3 out of 6 seats, that they had control. Now,
isn't it also true that your claims are not limited to the BCL?
I'm sorry, Your Honor?
Don't you also have claims beyond your BCL claim in this matter?
So there were breach of fiduciary duty and breach of contract claims. And in fashioning...
Would your remedies be limited to the BCL?
No, the remedies are limited. The remedies are not limited. I mean, this is the court has the power to, in equity, to fashion an appropriate remedy, particularly in cases like this where you have a breach of fiduciary duty. One of the roles of the court is to prevent future wrong and prevent future litigation. And we cite cases by this court on that point as well, that the court found ultimately that the only way to prevent future harm was to now, and only temporarily, limit the choose to 2 out of 6 seats. To be sure, this remedy is not a limitation on voting. The Chews are free to vote all the interests attributable to all of their shares. Nobody's being disenfranchised, and as Judge Tom held right before the election, every unit owner was free to vote all of their shares. The only limitation is on the number of seats that the Chew family can hold, and again, it's only for a short period of time. The court, in exercising its equitable remedies, could have made this permanent, but it didn't do that. It made it temporary, and the court also could have said that none of the Chews could serve on the board for a period of 6 years, but it didn't do that either. I think under the circumstances, based on the findings over the course of many years, I think that Judge Cohen was fairly generous in only temporarily limiting the Chews.
Thank you very much.
Thank you, Your Honor.
A couple of quick rebuttal points. Judge Pitt, you asked about what the court found. The court found that there were no damages from mismanagement. The Chews, if anything, were accused of running the place parsimoniously and keeping costs down, but there were no damages proven. With respect to Judge Higgett's question about the BCL, first of all, if you look at page 20 of the record, the lower court says that its decision is under Section 619. Doesn't say his decision is pursuant to general equitable principles. BCL 619 is captioned, powers of the Supreme Court respecting elections. I do not believe, and there is not a single case that has been cited that has ever, under general principles of law, allowed a court to simply decide for 7 years they're going to suspend somebody's contract rights.
Thank you very much.
Thank you, Judge. Judges.
The next case is Amber Capital versus Farrell.
Good afternoon, Your Honors. Matt Dolan from the law firm of Minor and Landis on behalf of the Appellant Signature Bank. Your Honors, the lower court erred here because the lower court failed to appropriately consider and apply the limitation on time provisions set forth under the account agreements that the ICI plaintiffs entered into at the time they became customers of Signature Bank.
Let me ask you something, because we're familiar with the case. You're making a motion to dismiss, so the documentary evidence has to be dispositive, which is the account agreement. Isn't it at best ambiguous in this case whether the claims that are being made in this action have anything to do with the account agreement, since the claims go way beyond anything having to do with simply the account, but involve loans and equity investments?
Sure, Your Honor. So as it relates to that question, I think that a review of the complaint, through a review of the complaint, you can see that all of the allegations in the complaint relate directly to the ICI plaintiffs' accounts and their account agreements, which establish the customer relationship between the ICI plaintiffs and the bank.
Why do the claims arise out of the accounts? Aren't they saying someone at your bank duped them into lending money to other businesses at the bank and investing in other businesses in the bank? That's not arising out of the, if true, not arising out of the account agreement. It's a separate claim having nothing to do with the account agreement.
I would submit that they arise out of the account agreements because the account agreements establish the customer relationship between the bank.
Counsel, did AMBA have an account agreement in any way, shape, or form with Signature?
No, and that's why we're not moving for, or we're not before this court as it relates to AMBA.
Okay.
So as it relates to the other two parties,
Are any of the causes of action for breach of the account agreement?
they are not, Your Honor, and we think that that was purposeful to avoid the application of the provisions set forth
Do
under
any of the claims have anything to do with the construction of any of the language in the account agreement other than your defenses?
Did the allegations?
To interpret whether they have a valid claim on their face, do you have to look to the account agreements in any way, shape, or form?
I think that you need to look at the financial services that they allege we provided them as customers as a benefit of being customers of Signature Bank. So they're alleging that certain financial advisory services were provided to them as a benefit of being customers of Signature Bank. They allege that certain funds were transferred from Signature Bank bank accounts that they owned from Signature Bank to another bank, Bank of America, and then eventually resulted in a loss. So it's our position that those claims and those claims related to the account agreement, which established their customer relationship, and the benefits that they received allegedly under that customer relationship, as well as the funds that were transferred from their bank accounts with Signature Bank to Bank of America, all relate to the bank account agreements and the accounts themselves.
There were some unusual aspects about their relationship with Farrell, correct? I mean, you'd concede that, right?
Excuse me, Your Honor, whether...
Their relationship, was it Mr. Farrell was their personal banker?
Yes,
Okay,
co-defendant
so
David
they
Farrell.
literally gave him blank checks. Is that part of the usual account agreement at Signature?
We don't, so those allegations are in dispute. I'm not saying that we
Yeah,
can
but this is a 3211 motion, so we can take those as true.
For purposes of this motion to dismiss, Your Honor, yes, I'm not conceding that any of those allegations are true.
Okay.
And just briefly, since it looks like my time is running up, part of our motion is also as it relates to the exculpatory provision set forth under the account agreements. I think that exculpatory provision is broad. I think that the lower court...
It doesn't have the same requirement that it has to be related to or arising out of the non-performance or performance under the agreement.
Your Honor, if you take a look at the exculpatory provision under the account agreements, it's set forth within its own sentence in its own separate line and paragraph, and it states, and I quote, ICI plaintiffs specifically waive any and all claims based on or arising from statute or tort, and specifically waive their right to recover from Signature on any claim of negligence.
But it has to relate to performance or non-performance under the agreement, under the express unambiguous language of the limitation provision.
Your Honor, it's my position that it doesn't, that it's set forth within its own sentence and it doesn't have to relate to the account agreements, only as it relates...
Even if it has nothing to do with the agreement whatsoever, it's completely unrelated to the agreement, like they was, I don't know, shot by a banker there, that would cover it?
No, Your Honor. I mean, I think that's a broad waiver of all negligence claims against the bank, yes. Does it have to relate to the account agreement? Well, I submit that it doesn't. However, if it does, then I go back to all my previous arguments, which I started with at the beginning of this case, and which we briefly discussed, which is that these claims all have to relate to the account agreement which established the customer relationship between Signature and the ICI plaintiffs. There would be no claim against Signature if they were not customers and they didn't enter into the account agreement with Signature, which governed the relationship between the parties.
Okay, you'll have a minute for rebuttal. Thank you.
Good afternoon, may it please the court. My name is Adam Cole. I represent the ICI plaintiff respondents. Justice Kern, if I may, I'd like to respond to the three questions that you asked because I think it gets to the essence of the case. The first is whether or not, if there's an ambiguous term of a contract, whether or not that is a subject to a motion to dismiss. We don't believe the terms of the alleged contract, which are really in a booklet that's attached or was allegedly attached to a signature page, were ambiguous.
And counsel, parenthetically, I'm sorry to interrupt you, but your clients also deny ever receiving that booklet, correct?
He denies receiving the booklet. Now, there is a provision, conceitedly, there is a signature initial where he says he did receive it. But this is the typical situation when people open up accounts. The account representative puts arrows and people just initial. I'm not saying that was correct to do. I'm just telling you that my client says he didn't receive the booklet.
And the booklet has a limitation provision and also the exculpation agreement, right?
Yes.
Okay.
Now, the exculpation provision, which I think was raised as well, well, let me just finish what I was going to say. If the language is ambiguous, it would be not subject to a motion to dismiss. It would be subject to discovery. Justice Kern and Justice Moulton, I believe you referred to the exculpatory provision. These are provisions that limit liability to breach of contract, to limit types of claims to breach of contract. But I think, Justice Kern, you said it correctly. You can't get around the language. It talks about limiting liability for the bank's performance or non-performance of this agreement. We did not allege breach of contract. In fact, we didn't even know these agreements existed.
We received them as part of the motion to dismiss because my client never received them. But even if we did receive them, we're not alleging breach of contract. We're not alleging that checks were not properly honored. We're not saying that there was a charge that was wrong. We're not saying that a deposit that was wrong. That's what this agreement deals with. Page after page after page talks about how the bank account is going to be run, how the bank runs it. There's nothing in this case about how the account itself was run. Justice Borick got it correct when he said the gravamen of the complaint is that signature throughout through its then employee David Farrell, was more than an employee, by the way, gained the trust of Anderson Innes and preyed upon him and his company in his construction to form AMBA in order to prop up certain other signature clients through loans and other equity investments while knowing that their accounts were in default and overdraft and that their businesses were fledgling. There is nothing in the booklet that my client says he didn't receive, nothing in the booklet that talks about propping up other bank account customers, other bank customers. Nothing in the booklet talks about proposing loans to other customers of the bank so those customers can be propped up. This has nothing to do with the agreement. The language that's relevant is it has to be with respect to an account or with respect to the agreement. There's nothing in the agreement, and I submit that the account is strictly an account for deposits and checks, not an investment account or an account by which services are provided to have the bank ask his client to provide loans to other bad bank clients. And for that reason, Your Honors, I respectfully request that the opinion be affirmed.
Thank you very much.
Your Honors, my colleague made a point to say that this case doesn't have to deal with the accounts, but a review of the complaint and the allegations made in the complaint evidences that this case is all about their accounts. It's about their accounts with Signature Bank. They allege that David Farrell caused them to build up their bank accounts at Signature Bank, and then they took David Farrell, allegedly informed them that they should move funds from their bank accounts at Signature Bank to Bank of America, and then enter into hard money loans and bad investments. And as a result of moving those funds from their accounts, they eventually suffered a loss. So it's my position that this case directly relates to the accounts, and it relates to the account agreements which established the entire customer relationship between the ICI plaintiffs and Signature Bank. I'll also just note, because it was brought up a number of times, Mr. Innes' denial of his receipt of the account agreements.
Well, counsel, if the money ever passed through a Signature account, then we're talking about accounts. That's what you're saying?
In the event where someone's trying to sue Signature for a loss related to their accounts, then yes, that is what I would say.
So even though they transferred it to Bank of America, that doesn't matter because at one time it touched the Signature account?
Well, they're alleging losses from their Signature accounts as it relates. They never had an account at Bank of America. Anderson Innes and Innes Construction, Inc. never had Bank of America accounts.
AMBA did, right?
AMBA did. That's right, Your Honor.
Sir, are exculpatory clauses construed narrowly or broadly?
So, Your Honor, I do not dispute that exculpatory clauses are construed within the courts of New York State and most courts narrowly. But my position is that as it relates to the respondent's case law that they cited, all of that case law related to instances where the court was construing inferred terms or implied terms. And in this case, our exculpatory provision is not inferred and it's not implied, it's explicit.
Thank you very much.
Thank you, Your Honors.
Harpaz versus Dunn.
If it may please the court, Brian Kishner from Kishner Miller Himes, representing the appellant. Your Honor, this is a case in which the lower court made findings of fact in order to reach its conclusion. If you look at the decision in order of the lower court, and it's on record page 9, Two conclusions of fact needed to have been reached. One, that the defendant made statements in the context as a board member. And two, under such a case, that a qualified immunity or common qualified immunity applied.
Counsel, why can't that be determined as a matter of law?
Sure.
Your allegation is that certain things were done at a board meeting and put in the minutes, and that was defamatory. Why can't the application of whether or not this a privilege be decided just based on that information, on the
Sure.
allegations?
Courts have ruled on this. The case of Keeling, which is cited also in the reply, and it's Keeling versus Salvo, 3D 436 131 NY 3rd 885 on the First Department 2020. And the reason I bring that up is the court spelled out exactly what the test is under that situation. The test is, one, if it is found that the common interest will apply, then the burden shifts to an evidentiary showing that the plaintiff would need to make to show that malice was then applied.
Counsel, and what factual allegations were inside that showed that there was malice? And I'm really just getting to the point. Weren't there independent complaints from the building super? There were independent complaints that your client had been harassing and yelling at other members of the staff, right?
Yes, but that comes a long time after the hostility that has built up between these two neighbors, which dates back to 1999. And the allegations of the complaint so state. Record page 17 on paragraph 18, this has been a long relationship between two individuals. It was not as in the capacity of a board president as has been concluded, okay? It was as neighbors that this dispute arose. It was because my client reported, okay, inappropriate behavior of the done, okay, at that time, which was one, reconfiguring inappropriately apartments.
But the defamatory
violating
statements,
New York City.
Counsel, I'm sorry to interrupt you, but the defamatory statements concern what the super told the board, right?
Among them, there's a lot of defamatory statements. One of them is simply, one is going to be harassment. Two was done in a way to publicly humiliate the client by posting it through the lobby, posting it on in the elevators.
But the content of the defamatory statement's the same, right? The defamatory statement's about the super and what the super said.
It was a defamatory, that is correct, and it was repeated several times, right, in several different forums.
So that's okay. And that's in paragraphs 41, 42, 45 of the complaint, I think. I don't mean to make you stop your argument, but.
It's located in several areas.
The point is, it all has to do with what the super came to the board with, and there's nothing in this complaint that I see that says that your client, or excuse me, the defendant, helped him manufacture that claim, or somehow should have known that the claim was false.
Well,
and that's the necessary malice if we posit that the common interest privilege applies in this case.
Yeah. Well, one is there has been an admission that there has been no investigation and that they don't know the truth of the allegations, that they concluded and rendered that as a conclusion. So that was admitted by the defendant. One. Two is there is collusion. There was allegations of that. It is stated within the complaint on 37, record 22. It's also on paragraph 38. And there was a pattern of harassment made for ill will. If you're looking, it's on record page 22, paragraph 37 of the complaint. And it says, that Mr. Nohan, with the encouragement of Dunn, encouraged the condominium employees to spread same untruths to their union and the condominium management company.
Thank you very much. You'll have time for rebuttal.
May it please the court, Hillary Frankel here on behalf of defendant, respondent Sue Ann Dunn. Your Honors, I'd just like to say that the IAS court properly found the common interest privilege was in place, and to the point of the court finding there was no actual common law malice or constitutional malice, at page 7 of the record in the determination, out of 62 paragraphs of a complaint, the court cited to and relied on what was depicted in the complaint as the comment of defamation. I'll read it. Super indicated continued pattern of harassment of himself and by staff by board treasurer. Board voted 3-0 to formally rebuke treasurer and insist that she refrain from interaction with staff on the building-wide business that had not been approved by the full board. Their very own complaint, including that statement, belies any sort of actual malice because there was a 3-0 vote to rebuke the plaintiff on the harassment claims brought by the superintendent against plaintiff appellant. That's what the court relied on. The court went back and relied on the allegations in the complaint to reach the determination that there was not actual malice pled with respect to the superintendent's complaints about harassment. And to the point that the harassment, when an employer gets a complaint of harassment, they don't ever usually make a determination if there is harassment immediately happening. They take it at face value and try to separate the two people, the complainer and whoever is being alleged of harassment. And that's what they did in this
Well,
case.
counsel, I guess the question is this issue of malice, if it should have been decided on the 3211 motion or at some point later, right? So why can't we assume that the fact that the judge found that there was no malice is a conclusion that was inappropriately made at that time?
Well, it wasn't, Your Honor, because it is in the complaint that an entire board voted to rebuke the plaintiff. So on that basis, there couldn't have just been harassment by one individual. I would also say that the Keeling and Vaca are easily distinguished from this case. Those both cases involve actual statements saying someone's a crook and, hold on one second, saying that's a crook and a hijacker in Vaca. That nothing like that happened here. And in Keeling, which I objected to in the first instance, having been brought up in oral arguments and not briefed, that is easily distinguished too because the two defendants in that case accused the plaintiff of owing the HOA fees of $80,000 and not providing records, which was patently false. So those are easily distinguished from the case at law before Your Honors. To answer your question, Your Honor, it's not a fact in dispute because they pled it and they're wedded to whatever they put in the complaint. And when they put in the complaint that the board voted 3-0, that's where they lost the idea to say it was malice by one person, one individual.
Couldn't there be malice by 3 people?
They didn't bring a claim against the board. They didn't bring a claim against Sue Ann Dunn in her capacity as board president. They did that by design, and it didn't serve them well because everything they've alleged was board president conducting board meetings having to do with board individuals and board business. Thank you.
Thank you very much.
In order to reach the conclusions, and it was conclusions that were reached, the court cites themselves cases that are summary judgment cases. And the reason for that is in order to get to the point of malice and concluding malice, okay, it is a finding. It is a shift of the burden, and it is for us then to prove malice. That's an evidentiary showing. So the way that Keeling held is once there is a showing that there is a common interest privilege, the burden does shift to us, okay, as the plaintiff, to then establish malice. But that's an evidentiary showing, as Keeling pointed out and laid out quite succinctly. And hence the lower court citing summary judgment opinions. The comment that it was only in the scope of board business is not accurate and not in compliance with the complaint, okay? The complaint talks about how complaints were made to the board, okay, in regard to other matters unrelated.
Thank you very much. Thank you, counsel. The next case is 9 Orchard Partners versus New York City Department of Finance.
May it please the court, Michael Fleiss of Schwartz, Sladgis, Reich, Greenberg, Atlas for the petitioner appellant.
I'm going to start with a question because I have a number of questions for you. How do you address the very well-established case law that all questions of property valuation are under the exclusive province of the RPTL, whether the claims involve overvaluation or undervaluation? And that includes the Court of Appeal case in Vernon and a number of cases from the Second Department, which explicitly state that it doesn't matter if it's overvaluation or undervaluation. If the issue is valuation, then it has to be an Article 7 proceeding.
But, Your Honor, we all concede that that's not true, because we all concede.
We don't all concede that.
Well,
That's
Your
why
Honor,
I'm asking you.
If a petitioner is challenging the method of valuation on a series of properties, even the Department of
Right,
Finance.
so counsel, there are clearly exceptions, but that is not your scenario here. So under your scenario, where it's clearly a question of valuation, how they valued the building for property tax purposes and how much taxes you have to pay for the building, how does it not fit under that well-established rule that it's irrelevant whether it's an overvaluation or an undervaluation? You have to bring an Article 7 proceeding.
Not one of those cases, other than the Mount Vernon case, deals with an undervaluation.
But they all say it. They all say it unambiguously. It's repeated again and again in the case law. That is, the point is not whether it's an overvaluation or undervaluation. It's whether it involves a valuation claim and a dispute about a valuation claim.
They say it, Your Honor, as a way of distinguishing between those other cases I referred to, where you're talking about a methodology of valuation on multiple properties. This is one of those Second Department cases.
Why would they bring up undervaluation versus overvaluation if there's no need? There has to be a reason why cases keep bringing up that it covers both claims.
Well, they may have gotten it from the Mount Vernon case, but the Mount Vernon case, aside from being pure dicta, said that in a completely different context.
Okay, well then let me go to the First Department case, which involves a J51 tax abatement. And they there held also that it has to be through an Article 7 proceeding. And that case sounds remarkably similar to this case. They're saying they didn't get the exemption, J51 exemption, that they thought they were entitled to, and that therefore had to pay more taxes, exactly like this case. And the court specifically focused on, since this is a case involving a single valuation of a single property, which involves the tax assessors, individual credibility determinations about the value of the property, you have to bring an Article 7 proceeding. How is that distinguishable from this?
That First Department case, as Your Honor said, deals with a real property exemption. We're not dealing with that
How is the
here.
reasoning of it any different? Whether it's an exemption or an abatement, how does it differ that those type of valuation proceedings have to be determined in an Article 7 proceeding?
The reason, Your Honor, is because Article 7 only includes those cases that are permitted under the terms of Article 7. And the precise language of Article 7 does not permit those.
Okay, so I understand your argument is it's not excessive, although you could twist it around and say it is excessive, but that seems to be your argument. But if that's your argument, then how do you explain, back to the beginning, the long line of cases saying it doesn't really matter whether it's overvaluation or undervaluation? If it's a valuation question, it goes to an Article 7 proceeding.
It's not precisely that it's not an excessive claim. 7014B says that a claim of an excessive assessment, one of the definitions is an entry on the assessment roll, which is excessive because the real property failed to receive all or a portion of a partial exemption.
But are we going to disregard the language of the Court of Appeals, which says undervaluation cases are also covered by Article 7?
The Court of Appeals said that, Your Honor, only in a hypothetical sense. The Court of Appeals said if we allow you to recharacterize your undervaluation claim as a claim of illegal assessment, which is what the petitioner in that case tried to do, if we allow you to recharacterize it that way, then every petitioner claiming an overvaluation or an undervaluation could characterize it the same way, and therefore all these cases could go to Article 78, and that would destroy the exclusivity of Article 7.
Okay, so I was going to ask, your time's up, but to my co-colleague.
I just have a quick question. Coming at it from the other direction, you're saying this is an error of description, but doesn't that error of description mean a ministerial error, not one like here that invokes expertise and discretion in the use of that expertise?
I think, well, the Department of Finance has said that, but they haven't cited to anything. There are certain examples under the New York rules which are ministerial, and there are other examples which are not ministerial. You can't characterize, you can't say from a small list of the examples that are given, therefore all of them have to be ministerial. That would pretty much do away with the distinction between a clerical error and an error in description. There'd be no reason for the two separate.
Are there any other questions from the bench? Okay, thank you very much.
Good afternoon, Your Honors. My name is Paul DeSena from the New York City Law Department, and I represent the respondent in the New York City Department of Finance in this case. I mean, I think we do.
Let me ask you, because he's
Yes.
relying on the statutory language, which talks about
Sure.
excessive. What about his argument that this is not excessive and therefore it doesn't, based on the language of the statute, this should not be an Article 7 proceeding?
I mean, first of all, we would, it's our position that any question of valuation over or under belongs in Article 7. As to the specific language in 701(4)(b), whereby a petitioner may sue on the grounds that he's excessive for any failure to obtain a partial tax exemption. That language could, in fact, be a catch-all, and we see the word exemption used as a catch-all in Section 1 of Article 16 of the New York State Constitution, which, whereby the Constitution reads that an exemption must be passed by general and not a specific or local law. The courts have ruled that the word exemption in that instance actually could mean literally any tax relief program.
Counsel, while that may be true, in this particular section, they use the word exception, and throughout the other parts of this section, they use the word exemption and abatement. So the leaving out of the word abatement, isn't that what the legislator intended then?
Your Honor, no, we would say that no, it isn't. And actually, that if you look at the way the ICAP abatement itself is calculated, that it's calculated broadly in the difference in tax liabilities between the initial tax year and the post-completion tax year. And because it's calculated off of tax liabilities, what you need to do, it actually presents in an Article 7 context a dual question of overvaluation and undervaluation. If you lower the tax liability in the initial tax year, you raise your abatement. But really all you're looking at for the purposes of ICAP is the assessed values, because the tax liabilities are directly derived from those assessed values. So it doesn't actually matter. Plaintiff's statutory argument on this point doesn't actually matter. It's irrelevant because really all you're looking at when you're looking at your ICAP abatement is the assessed values in your initial tax year and the assessed value in your post-completion tax year.
Sir, Article 7 talks about assessment, right? That's the main word that permeates Article 7. We're concerned with assessment. Is the calculation of this particular abatement a quote-unquote assessment?
No, we don't believe that it is. It seems to be a special calculation prescribed by statute, whereby the tax liabilities between two tax years are actually are used to reach that particular abatement. But really, it gets to the core point of what this case is about and what the underlying case is about. Petitioner is seeking to assail the valuations of certain physical increases on his property in certain tax years. These are, these are discretionary. These are based on the judgment and discretion of city assessors, and they belong in Article 7 for that reason. Further, I would just say that as to petitioner's claim of petitioner's methodological attack Petitioner only really assails the methodology of his own two properties. This makes it even clearer that this is an Article 7 matter because, you know, only in an Article 7 can you really get down into the weeds of what methodology was used on a specific property in a specific tax year to assess that property.
How would this be decided in an Article 7 proceeding versus this proceeding? If we were to decide it in the context of an Article 78, how would that differ from the way it would be decided in an Article 7 proceeding?
Well, Your Honor, first of all, in an Article 7, it would allow for review of the specific tax years. And secondly, we don't actually believe that the valuations can be reached under the rubric of the Article 78 as they were presented to the lower court. Petitioner has stated that the property valuations in his specific tax years are actually clerical errors or errors in description. These are provisions meant to deal with ministerial errors of form, and because of that, you can't even reach the valuations through administrative review here. It's actually, we would argue that it's impossible to decide this through Article 78, and that it only belongs in Article 7.
So you're saying separate and apart from whether Article 7 is exclusive, this is not appropriate under Article 78?
Correct. And if Your Honors have
Are
any...
you not disputing that there is jurisdiction under Article 7 and that you would take full jurisdiction over the case under Article 7 and address all the issues raised?
Well, actually, Your Honor, as to that point, they've actually already filed 8 Article 7 claims from 2012 to the present.
And you're not challenging the jurisdiction in those cases?
No, Your Honor.
Thank you very much. Any other questions? Okay.
Thank you.
Just return for one moment to the language of 701(4)(b). An excessive assessment includes an entry on an assessment roll of the taxable assessed value of real property, which is excessive because the real property failed to receive all or a portion of a partial exemption. The difference between exemptions and abatements is that exemptions reduce the value of the property and then apply the tax rate to it. An abatement taxes the property at the full value and then reduces the tax once it's been calculated.
Don't they both go to the valuation of the property, how you value the property, and then how much taxes are due based on how the individual tax assessor assessed that individual property?
That's true, Your Honor.
So those are identical issues in both abatement and exemptions.
Identical issues, yes, that's true, but the Court of Appeals made it clear. Court of Appeals made it clear in the Kahal B'nai Emunim case that challenges to real property assessments which allege the assessment is excessive, unequal, or unlawful, or that the real property is misclassified must be asserted in a cert proceeding pursuant to Article 7.
Thank you. Are there any other questions from the bench?
Sir, what specific relief do you want in this proceeding?
We want
this Article 78 proceeding.
An increase in the amount of, what the Department of Finance found to be the abatement base here. We want that amount increased from the $2,400,000 that they found to over $20 million.
And what Article 78 mechanism would allow the court to give you that relief?
I'm not really sure, Your Honor, but challenges to actions by governmental agencies, Article 78 is always the way to challenge those things unless you're required to go another way.
Thank you. Any further questions? Thank you very much. The next case is International Finance versus Humbrecht. Don't you want to argue?
Good afternoon. David Richan for the defendant appellant. Defendant appeals from a grant of summary judgment in lieu of complaint by the lower court. This case turns on the meaning of one word. It's a word that's well known and understood by both lawyers and laymen, and that word is shall. Almost 9 years before this...
Let me interrupt you. We're applying Delaware law here, we're not applying New York law. And your argument is that that first alleged breach, started the statute of limitations ticking. But what about the very specific case law in Delaware that separate breaches are separate claims and separately start the statute of limitations for accrual purposes?
Those cases don't involve a mandatory acceleration clause, which this case does, and that's what this case turns on. When the first breach occurred,
What's your support for that? What in the Delaware cases supports this argument?
the Wells Fargo case we cite, page 6 of our brief, says on a promissory note, and that's what this case is, the action accrues at the time of the first breach. That's Delaware law under the Wells Fargo case. With an acceleration clause, and this is black letter law, with a mandatory acceleration clause, when a breach occurs, and a breach definitely occurred, there is no dispute that a breach
Just going back to the Wells Fargo case, that was a breach on the actual promissory note, right? It was a non-payment pursuant to the promissory note. It wasn't, as here, the failure to provide certain financial documents, right?
With all due respect, Your Honor, that's incorrect.
Oh.
Because of the mandatory acceleration clause, payment was due immediately and in full, and it's mandatory. It's not optional. Plaintiffs has been arguing, well, we're suing on the 2015 breach.
What about the Bean case, which says if there's separate breaches, there's separate claims and separate accruals? How do you distinguish the Bean versus Mercer case in the law?
I don't believe that case had an acceleration clause. The acceleration clause changes everything.
Why does the acceleration clause change that very broad principle that's articulated?
Because with a mandatory acceleration clause, which the parties agreed to, this is plaintiff's clause in his note, everything becomes due and payable immediately upon the breach of a covenant in the guarantee. And that breach occurred. There is no dispute about that. Financials were never provided. That is a breach of a covenant. A breach of a covenant is an event of default, and upon an event of default, the whole thing is due and payable, and a cause of action accrues immediately.
So you're saying that under the...
Go ahead, please.
So you're saying that under the contract, the plaintiff was compelled or required at that point to accelerate the debt?
Yeah, yes, Your Honor, by operation of the contract, it was accelerated. He didn't have to do anything.
Counsel, how should we look at the non-waiver clause that was in the contract?
Non-waiver clause is not implicated here, Your Honor. Nobody waived anything. They're not claiming they waived anything. They didn't say, we waive the acceleration clause. They just didn't enforce it. That confuses, with all due respect, that confuses the concept of waiver with the concept of the statute of limitations. There was no waiver here. They didn't waive anything. They just, when the time came to enforce their rights, they didn't do anything about it.
Counsel, just going back to Wells Fargo for a minute, I want to make sure how I misunderstood, and I may have misunderstood, but I thought the breach in Wells Fargo versus Strong was a failure to pay under the promisory note.
So is this. The promissory note was due in full at the time of the first breach.
But the first breach that you're saying causes the accrual is something separate from that, is the failure to provide financial documents, correct?
That's not a separate, under the agreement that the parties entered into, upon the breach of a covenant in the guarantee, this particular covenant, and it was breached, the debt's accelerated immediately and the whole note is due on that date. That's the date that the cause of action accrues. That's when the contract was breached. You can sue on 10 different breaches if you want, but as for when your cause of action accrues, it's on the first breach, and that's what Wells Fargo says 8109 provides.
Thank you very much.
Thank you.
Good afternoon. May it please the court. Matthew McLaughlin for the respondent plaintiff, International Financial Group. The lower court should be affirmed. Justice Cohen got it correct. We are not suing for the failure to deliver financials under that other 2012 guarantee agreement. We are suing for the breach of a $12 million promissory note that was not payable until 2015. Justice Cohen recognized under Delaware law that separate breaches trigger separate statutes of limitations running. And, Your Honor, you're correct. The Wells Fargo case was a promissory note case. There was only one document at issue there, and the question in Wells Fargo was when did the time running on a series of breaches. We are dealing, in this matter, with two entirely different kinds of breaches. There's the 2015 promissory note for $12 million, on which a cent has never been paid, and there was a collateral guarantee agreement signed the same day as the note, and there were collateral minor covenants in that guarantee involving financials that, yes, were not given. I point the court, as Justice Kern started, this is governed by Delaware law. There is no dispute about that. Delaware has a developed body of law that says acceleration clauses are not self-executing. Rather, these types of agreements confer on the holder the option to declare an acceleration. And as Justice Pitt has pointed to already, we have a no waiver clause in our note. This note is not an automatic acceleration note. Delaware law would not permit that anyway, but even if you disregard Delaware law, we have a no waiver provision that says failure of the holder of this note to exercise any of his remedies shall not constitute a waiver.
Let me ask something though. If we accept your first argument that under Delaware law there's separate breaches and one does not affect the other, do we get to the no waiver provision?
Your Honor, you can affirm on that independent basis that you just articulated.
But they're totally independent, aren't they?
They are separate wrongs, separate sins, separate statutes of limitations ran at separate times. We're suing only on the note which became due not till 2015. We are not suing for the failure to deliver financials in 2012. That was a de minimis, nothing of an issue that no one seems to even notice about. One last point before I conclude, Your Honors. In the note itself, after that sentence that my colleague pointed you to in the record on page 19, the very last sentence of that paragraph to which you were directed has a sentence that's not referenced in his brief, and he didn't reference it in argument. The last sentence says, "Maker shall notify creditor of the occurrence of any event of default." Now, if the appellant wants to offensively use that 2012 breach against us and start our statute of limitations running on a note that doesn't even become payable in 2015, this last sentence that I just read to the court requires the appellant to have given notice of a default. So this should be affirmed because of Delaware law, should be affirmed because of the no waiver provision on the record at page 20, and should be affirmed because of appellant's failure to give notice at the time of that 2012 breach. Separate breaches, separate statutes of limitations. We respectfully ask that the lower court decision be affirmed.
Thank you very much.
Thank you.
I just want to briefly address my adversary's arguments. First of all, the note wasn't payable until 2015. That's not true. The note was payable in 2012. Why was it payable in full in 2012? Why? Because plaintiff's note says so. In event of default, maker or a guarantor shall fail to perform any term, covenant, or condition contained in the note or the guarantee. Upon the happening of one of these events of default, the entire unpaid principal balance due under this note and any accrued interest thereon shall become immediately due and payable. My adversary cited the two cases that—
I'm sorry, but isn't the immediately following sentence material, and that is the maker shall promptly notify creditor of the occurrence?
Well, two things. One is, that's just another breach that occurred back in 2012. So that's just another reason to have the cause of action accrue. But second of all, that notice provision does not make it a condition precedent to acceleration.
Thank you very much.
Thank you, Your Honors.
People versus David Williams.
Good afternoon, Your Honors, and may it please the Court. My name is Cara Labini for Appellant David Williams. The court below erred in denying an independent source hearing because there was no clear and convincing evidence below that the encounter at the precinct did not in some way help the undercover ID Mr. Williams at trial. The court needed a baseline description of what happened at the precinct in order to properly make that determination. The court did not know how long the undercover might have stared at Mr. Williams for at the precinct. The court did not know.
Counsel, did the defendant make any allegations that the confirmatory ID process at the precinct was in some way unduly suggestive?
Suggestiveness does not matter. It does not matter whether the confirmatory ID was in fact merely confirmatory or whether it was more, suggestiveness is not on point here at all. A taint analysis, which is what the independent source hearing is ordered to determine, is wholly dependent on the causal relationship between the illegality and the ID, the in-court ID in this case.
Well, counsel, the undercover officer, was there any testimony that he had the opportunity to observe him during the hand-to-hand by when he was introduced to him by the Elfie, and then Elfie pointed out pointed out Mr. Williams? I mean, there was ample time on the street, right?
So
to form an independent source.
The undercover and Mr. Williams were allegedly together for about a block. They met on 116th and 1st Avenue, walked while the undercover was behind Mr. Williams to 115th Street. Mr. Williams and Mr. Elfie allegedly crossed the street and the undercover waited. The undercover never was anywhere near Mr. Williams after that time. So, you know, I think that these are the merits that need to be litigated at a hearing, because clearly the facts of what happened at the precinct are the determinative issue here, because the prosecutor had to introduce clear and convincing evidence that whatever happened at the precinct did not impact, did not help the undercover identify Mr. Williams at trial. And given that the two were in each other's presence for so little time, and that the undercover was behind Mr. Williams for all of that time.
But the totality of the circumstances that the undercover would have testified to would have lent that there was an independent basis. I understand that you're saying that it was a short amount of time, but based upon the details that the undercover provided that happened or occurred prior to the hand-to-hand, even after the sale was made, that totality is in of itself is an independent source.
Well, I
Under
think you
Wharton
have
and
to
Shepard,
have the
right?
details. You have to have details of what the event that's supposed to be independent from the in-court ID, what the event was. How can you say that X is independent from Y if you don't even know what happened during X?
Counsel, isn't the independent source the real aim as to see what was the quality and the opportunity of the undercover to see whoever it was that was selling? Isn't that what's at issue here?
Yes, Your Honor, but it's
and with regards to that, you phrased it as, you know, the time was small, but I think the lower court found otherwise, right? The lower court found that there was an extended amount of time here that they interacted each other. The one person tried to introduce the undercover to your client. Your client walked over to the undercover. It's not just it's not a fleeting passing or a glance, right? We're talking about a sequence of events that lasted about 10 to 15 minutes.
Well, not the walk from 116 to 115. That did not.
No, not the walk. I'm talking about the totality, as Justice Pitt just said.
Well, the undercover described his interaction with Mr. Williams as very minimal, and that's at page 203.
The interaction, that doesn't mean he didn't see him.
Well, the rest of the time they were more than either a half a block away from, a half a block away on First Avenue or completely across from First Avenue. So the suggestion that he could have had a better opportunity to view Mr. Williams during another time besides that block-long walk does not hold merit.
Sorry, counsel, it's at some point, maybe at page 204 or 205 of the hearing transcript, didn't the undercover testify that he was within, quote, a couple of steps or a couple of feet away from the defendant?
That's true, but he was also behind him. So the in-court ID is not affected by that. And I think this, just to wrap up, the undercover officer never identified him by his features, only what he was wearing.
Thank you very much.
Good afternoon, Christopher Marinelli for the respondent, people of the state of New York. Just quickly, I'd like to note that the hearing court has heard none of the arguments the defendant has presented to this one. The defendant made a rather hyperbolic suggestion that there was no testimony on point. The hearing court pointed out there was actually quite a bit of testimony on point. And
Counsel, why don't you address the opposing counsel's position that how's the court supposed to determine if there really was an independent source, if there was any taint, without knowing what happened at that confirmatory ID?
Well, it is a totality of the circumstances, so you have to look at both halves of the equation. I would point out that the testimony is that Mr. Elf points out defendant when he's walking up 116th Street and says, "That's my guy," and then they comes over crosses the street. There's a conversation that the undercover is close enough to hear.
I don't think you need to go over that because that's exactly what I was going through with opposing counsel, that there is that testimony. But to her position, or her argument that the court knew nothing about, or very little about what happened at the precinct. Why don't you address that?
I'd say mostly, but the way the extended opportunity he had, it doesn't make sense to believe that he would only have recognized him from the confirmatory ID. And yes, there could have been more detail about that. There could always be more detail on any subject. The Warren Commission could have gone into more detail, but when you look at everything together, the hearing court's determination was well-founded, that really it was from the extended opportunity and interaction that is why the defendant or the undercover could identify the defendant.
So contextually, this map Dunaway hearing gave us enough of the picture to provide for us, as Justices Pitt and Rodriguez mentioned, the totality of the circumstances?
Yes, Your Honor. And it's not ideal, but as a practical matter, it is often decided in this manner, and where you have sort of hearings on sort of related issues, and maybe no one really focuses on the question of independent source, but if there's enough of a record developed, and I think what happened in this case is, I don't think the defendant made a boilerplate request for the independent source hearing. It wasn't clear that the undercover was going to be called. Once the undercover was called, I think everyone pretty much assumed that it dropped out of the case until 4 months later, when the defendant makes an motion to re-argue, suddenly asking for a confirmatory identification. If it had been brought up promptly, maybe a further record would have been developed, but the existing record amply supports the hearing court's determination. If there are no further questions, we'd ask that you affirm. Thank you.
I want to be very clear about the standard that should be applied here under our now. There can be no connection between the precinct ID and the in-court ID. That connection cannot be direct, indirect, proximate, nor attenuated. My adversary is suggesting a different standard, which is that if the in-court ID was at least partly based on pre-arrest conduct, then the in-court ID was properly admitted. That's not the standard. And I just also want to say that it is easily imaginable that at the precinct, if the undercover had numerous seconds, not long, he didn't need long, to view the defendant's face, perhaps without his hat on, without a sweater on, without a jacket on. This is December, so he was wearing, sweaters. That influenced his in-court ID. It's a second encounter where his memory could have been refreshed, and in our in our lives, that happens to us too, and I think that's easily imaginable here. Thank you very much, Your Honors.
Haskin versus New York State Division of Housing.
Good afternoon. May it please the court, Robin LaJudas for the tenant appellant in this case. There are three major issues raised on this appeal. The validity of the landlord's claimed IAI increases, the landlord's claim that a review of the rent history was barred by a 4-year statute of limitations, and some substantial due process violations against the tenant. I'll start with the statute of limitations issue. The landlord has conflated two issues here. One is the strict statute of limitations that's 4 years for damages, for rent overcharge. The second one is the look back.
Yes, counsel, I think we know the difference because east-west, of course, is a precedent that we continue to cite in this court.
All right.
Maybe you want to talk about the IAI?
Absolutely. I'll move right on from that. So the DHCR found indices of fraud in a preliminary finding below, early on in this convoluted case. They sent 2 final notices to the landlord with a detailed statement that said, the evidence shows indicia of fraud. These are the things you need to show us. Now, the DHCR is asking the landlord for proof that goes way beyond 4 years. So the landlord initially, over and over again in the process since 2015 that this has been going on, said they're barred by the statute of limitations, the 4-year statute of limitations. Please decide the case. Eventually, on the second notice, and by the way, I'm sure you've read the brief, these were never provided to the pro se tenant, who, or even later when she was represented by our firm. The landlord finally produced documents. So those documents were not sufficient to satisfy what was controlling at the time of the purported
You'd concede,
deregulation.
counsel, you'd concede the DHCR can also use its own experience in roughing out what it would cost to renovate a one-bedroom apartment that had been vacant for at least 21 years. They can use their own experience too, right?
I disagree respectfully, Your Honor, because what they found was they had to rely on the proof that policy statement 90-10 required, which is very easy. You only have to do one of the things that are required with the DHCR. Cancel checks, those were not provided.
Thank you, counsel. Thank you very much. Liberty Mutual versus Old Republic General.
I was mistaken. May it please the court, Marshall Petitioner for a plaintiff appellant. First, I'll start with the issue on travelers. The court below erred in applying the duty to defend standard. No reasonable dispute exists that a vicarious liability claim exists against 170 Broadway in the underlying action. This court determined as such in the underlying action on appeal when it held, quote, there remains a question of fact as to whether it had actual or constructive notice of this hazardous condition and thus was more than just vicariously liable.
Your position is that if the only issue remaining is whether they were or not negligent and there's disputed issues of fact about that, that's sufficient to invoke the duty to defend.
Yes, that question of fact, whether it's vicariously liable or actively negligent, invokes the duty to defend. And in fact, the travelers and the court below ignored that 170 Broadway may be liable to Spielman under the administrative code because of the negligence of its contractors, and that as between DiMartino and 170 Broadway, that liability may be vicarious. Now, moving on to PCIC and Old Republic. Both of their arguments fail because PCIC and Old Republic ignores both the language of their own policies and that they failed to submit any evidence whatsoever of prejudice to support their late notice defense. Thus, that makes when Liberty Mutual first received notice immaterial and not a basis for denying summary judgment.
Why isn't there an issue of fact as to prejudice?
Because they didn't submit any evidence. And in fact, the PCA, they didn't submit one iota of evidence. In fact, if you look at PCI's brief, they don't even mention prejudice or argue prejudice at all. Old Republic doesn't argue prejudice. Now, as far as on a summary judgment motion, we submitted evidence of a lack of prejudice. And they were obligated to come forward with some evidence of prejudice to avoid summary judgment. They did not. Plus, PCIC's language specifically says, notice given by or on behalf of the insured with particulars sufficient to identify the insured shall be considered notice to us. On June 8, 2015, Old Republic specifically gave notice to PCIC on behalf of 170 Broadway. That notice was on behalf of and specifically identified 170 Broadway as an additional insured. Moreover, Liberty Mutual, going to your Honor's prior question, submitted substantial evidence of no prejudice by PCIC. PCIC's claims handler at a deposition testified as such, no prejudice. PCIC's admission that it conducted no investigation when DiMartino, another AI, tendered its claim, which PCIC did accept. And also, PCIC was disclaiming coverage anyway, so an earlier notice would have only resulted in an earlier disclaimer.
Is that relevant under the law, though?
Yes, there's actually
under the law?
Yeah, there's actually a Second Circuit case applying New York law, looking at.
What about New York law? What do we say about that?
You haven't addressed that issue, but other states have, and the Second Circuit applying New York law has. In the face of such evidence, they had to come forward with something. They didn't come forward with anything to address Old Republic's issues. Old Republic's policy says notice given to the company by one named insured or insured shall constitute such notice by all named insureds and insureds. Well, McGowan provided notice to Old Republic on April 13, 2015, and they're defending McGowan. That notice, pursuant to their own language, which is allowed to be more liberal than what the law requires, and it is more liberal, is sufficient on behalf of 170 pursuant to the terms of their own language.
Did Liberty Mutual ever provide notice to Old Republic directly?
Liberty Mutual didn't.
Other than bringing the suit?
Well, Liberty Mutual didn't know who Old Republic was at the time, so they sent it to.
It never gave notice.
They gave notice to McGowan, who gave notice.
But they never directly gave notice to.
Yeah, the implication is, why is Old Republic going to PCIC to defend 170 if McGowan didn't say, hey.
Again, is that enough under our law, this indirect notice? The fact that they might have known, is that enough without you giving notice to them?
Yes, because there's two elements of the late notice defense. Was the notice late? And let's assume that's an issue of fact here. And there's prejudice. There's no issue of fact here. We submitted the claims, the Old Republic's claim handlers' own admissions that there was no prejudice, that they were aware from the beginning that 170 Broadway would be seeking a defense, that they protected their interests by tendering the defense of 170 onto PCIC's insurer, that Old Republic was able to investigate Spielman's claims because it was already defending McGowan. Old Republic in opposition, and if you look at their brief, they don't even argue that they suffered any prejudice. The best they have is they quote.
I'm going to let you respond to that in rebuttal. Thank you.
Okay. Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Joanne Engeldrum from Rivkin Radler on behalf of Respondent Travelers Indemnity Company. The court below properly found that Travelers...
Let me ask you something, counsel. I know that the might not have been the most clear decision from the First Department in the previous case, but wasn't the actual holding that there's an issue of fact as to whether or not there was negligence on the part of Broadway, and wouldn't that the fact that this issue of fact be enough to invoke the duty to defend?
Your Honor, actually, this court found that 170 Broadway was, in fact, negligent.
Well, the language of the decision is a little unclear, but vicarious liability under the statute, under the administrative code, is not negligence. You have a statutory duty to maintain the sidewalk, even in the absence of negligence. So the court does seem to very clearly be saying that there's liability under the statutory duty, but there's an issue of fact as to whether there was active negligence in terms of notice. So that being the case, even though they use the word negligent, why doesn't that invoke the duty to defend?
Because we maintain that vicarious liability is not at issue here. This court, as well as the court below, found that 170 Broadway was negligence, and the Court of Appeals...
Well, what do you mean by negligent? Negligent vicariously liable, or negligent in terms of negligence, traditional
negligence in terms of their failure to maintain the sidewalk and the travelers...
Liability under the administrative code does not require negligence. To be found liable under the administrative code, you don't have to be negligent. You just have to fail to maintain the sidewalk, which is a different issue than whether it's independent negligence.
Well, and what's at issue here is Travelers' additional insured endorsement, which does not provide coverage, not for negligence, but for independent acts or omissions. And here, it was 170 Broadway's omission in failing to
If they're only liable because they own
maintain.
the sidewalk.
Pardon me?
If they're only liable because they own the sidewalk.
They're liable for failing to maintain the library. And just one other point in that same regard is that to the extent that there's liability on DiMartino, Travelers named insured, that's DiMartino's liability. DiMartino is a defendant in the underlying action. So in this situation, 170 Broadway is being sued, and their alleged liability is based upon their own independent acts or omissions. DiMartino is being sued for their own negligence, McGowan is being sued for their own negligence, and Colgate is being sued for their own negligence. All of them are defendants in the underlying action.
Right, but that's not really answering the question of what finding has there been yet that 170 Broadway is negligent, separate and apart from their statutory duty to maintain the sidewalk?
Those are the sole allegations against 170, that they
Isn't there
are
an allegation that they are actually negligent, and the appellate division found there was an issue of fact about that?
There are, the sole allegations against 170 Broadway are that they were in fact negligent, and that is the alleged basis for their liability. And for purposes of duty to defend, you assume that the allegations against the purported insured are true for purposes of assessing coverage. And here, it is affirmatively alleged that 170 Broadway was in fact negligent, and that is the basis for their alleged liability. And we maintain that that is not sufficient to trigger a duty to defend under the Travelers policy.
Thank you very much.
Thank you.
May it please the court, Catherine McGuire-Tedrick from Ken McGuire & Associates, representing Old Republic. The simple fact of the matter...
the issue of prejudice, since opposing
get right
counsel
to it.
seem to make a big deal about that.
Okay, so the issue of prejudice, Liberty's counsel states that there was no prejudice. That is not what's in the record, and Old Republic certainly argued that there was prejudice. While Old Republic's claims representative, Mr. McCune, did not specify the prejudice in his deposition, there's clear prejudice even from the fact of the matter that we have this lawsuit where Liberty Mutual nor 170 Broadway ever actually tendered coverage to Old Republic. Instead, what happened was Liberty Mutual tendered to McGowan, didn't tender to Old Republic, gave McGowan a copy of the certificate of insurance, acknowledging that Liberty knew that Old Republic was a carrier, but didn't give the tender to Old Republic.
Well,
And
what
then,
about their argument that that doesn't matter? As long as you had notice, it doesn't matter how you got the notice.
well, we didn't have notice, Your Honor, that's the point. My client didn't actually receive notice until they got a copy of the summons and complaint. We only found out about the letter to McGowan through discovery in this action. So we did not actually get any notice at all. And the proof is in the pudding. The prejudice here is that we were put in a defensive posture where we were required to expend money on a declaratory judgment action when we weren't given the opportunity to either say yes or no to coverage to 170 Broadway first.
Is that enough to show prejudice?
That it's, in our point of view, that should be sufficient, yes, to show prejudice. Regardless, however, there is an issue of fact as to the length of time in which Liberty Mutual and 170 Broadway actually knew of the request for coverage from Old Republic and how long of a period that they failed to provide coverage. Liberty Mutual never provided concrete confirmation of when they knew about the Old Republic policy. The Liberty Mutual individual was deposed. He had 20 years experience at Liberty Mutual as a claims rep, and he could not say why he didn't tender to Old Republic or if he knew why it said certificate of insurance, but it wasn't included. And there's simply no factual statement as to when Liberty Mutual knew. So therefore, there's a question of how long they knew and whether or not the burden is on Old Republic or Liberty Mutual to show the prejudice here.
Just a follow-up on that. In what way or ways was your ability to defend this matter hindered?
Old Republic was not permitted to provide a defense to 170 Broadway for at least a year, if not longer, depending on how long the underlying action had gone forward, and we weren't given the opportunity to go in, discuss with 170 Broadway, interview their own people, have a setup of our own investigation into what their point of view was and their defense was. And since we were denied that, that's prejudicial as well. Thank you, Your Honors.
Thank you.
Good afternoon. May it please the court, Ross Hoffer from Harris Beach for respondent PCIC. In this case, there is an issue of fact as to when Liberty Mutual knew about the claim and when they tendered, and what the length of time was from when they knew about the claim until when they tendered to PCIC on May 3rd, 2016. There was a letter from Gallagher Bassett that was not from Liberty Mutual, that was not from 170 Broadway, that came earlier, but that is an independent source that does not provide adequate notice to PCIC under the policy. The trial court determined appropriately that there are issues of fact because Liberty Mutual refuses to disclose and did not disclose when it learned of the claim or the underlying action. Because of that, Liberty Mutual's timeliness in tendering its defense cannot be determined as a matter of law.
And sir, in what manner was PCIC's ability to defend prejudiced by the lack of timely notice?
Thank you, Your Honor. The PCIC's ability, PCIC was prejudiced in the same way that, similar way that Old Republic was prejudiced, that they weren't able to speak with 170 Broadway. They weren't aware of this claim. They weren't able to investigate it properly because of the time that had elapsed. Additionally, because there are more than 2 years had elapsed from the time that Liberty Mutual or its insured could have tendered to PCIC, the burden is on Liberty Mutual to prove that there was no prejudice. They haven't done that. That's their burden, it's not ours.
Thank you very much.
Thank you.
Thank you, Your Honor. To address the prejudice by Old Republic, they're reserving rights. They're not admitting that we're an additional insured for a duty to indemnify. They, in fact, argued originally that we didn't entitled to a duty to defend. But even if they came into the defense with a reservation of rights, they would have never been allowed to control the defense. The DJ action is not prejudicial. If they're saying, well, they had to defend the DJ action, instead of answering, they could have said, oh, I'm sorry, we'll defend you. Plus, they're ignoring their own policy language that says that a tender by McGowan is a tender by all insureds. They put that in their policy. They're bound to it. So we did tender. We tendered because McGowan tendered. With PCIC, they again ignore their own policy language. The policy doesn't require a tender by the insured. It says on behalf and identifying the insured. And McGowan's tender was on behalf of 170 and identified 170. With respect to, if I may, just with respect to the...
2 sentences, that's the travelers.
Let me just finish on the PCI real quick.
No, counsel, you can have to say 1 sentence about travelers and that's it. Or she can say 1 more sentence and that's it.
Okay. This court used the word vicarious in its prior decision in the underlying action in discussing the nature of the issues and claims left in the underlying case.
The next case is Quipu versus Weissman. Is it, what? I gave him 4 minutes.
Good afternoon, Your Honors. May it please the court, Anthony Gentile on behalf of Naomi Minnie Quipu, the plaintiff respondent in this case. Thank you for this opportunity to be heard in person. In light of my adversary's absence, I will address a few brief points and take the court's questions, which of course is more important. In the first place, in order to escape liability, the defendant here is attempting to impose a duty that no court has ever imposed upon a plaintiff before. A duty that while the plaintiff is walking on a public sidewalk, that plaintiff has a duty to be aware of cars that might come up from behind her and strike her silently from behind. There's just no support for that. Can I lower this mask a little? I'm sorry.
You have to keep it up your nose, though.
Okay.
If you want, you could submit, and then you don't have to worry.
No, I'm
We'll
okay.
see if we have any questions.
I'm okay. The duty that defendant is attempting to impose is an unworkable duty, because how far does the duty extend? Does it extend to the elderly, the infirm, the handicapped, people who may use walkers, people who may be pushing strollers? It's simply an unworkable duty. And if you're going to impose that duty, what I think the court should do is limit it. Maybe the plaintiff has an obligation to be aware of cars crossing in front of her, maybe coming from the side, but certainly not from behind her. And even if the court was to impose this duty, even if the court was to impose or reinstate the comparative negligence claim, we still have the Rodriguez case to contend with, which states that a plaintiff need not reduce her comparative negligence to 0 in order to obtain summary judgment. I see that my white light is on. I will take questions from the court.
Any questions? No questions.
Okay, then we ask the court to uphold the lower court's decision in 2 regards, which is the grant of summary judgment in plaintiff's favor and the dismissal of all of defendant's affirmative defenses. Thank you.
Thank you very much. And our last case of the day, Aristocrat Plastic Surgery versus Silva.
Good afternoon, Your Honors. May it please the Court, Bryce Jones, Jones Law Firm, PC, for the appellant defendant, Paige Silva. This case comes down to one word, in my opinion, and that's the word purely. The statute at issue here reads anything other than a purely private matter. That language is unique to New York State. The legislature meant it to be extremely broad, as we know from the bill jacket and other materials. And purely private matter does not extend to reviews posted on a business website for Yelp, participating in the commercial marketplace, and reviews directed at other consumers of that business. In this case, the business is a medical practice. It doesn't extend to reviews of a doctor either. The second part of this analysis is the plaintiff respondent's best argument you'll find on page 14 of their brief. I encourage the court to read the entire paragraph of Albert v. Loxon. This case doesn't involve a Yelp review. This is the Second Circuit case. The quote from the first sentence says, publications directed only to a limited private audience may be matters of purely private interest. And they're citing there Huggins v. Moore, which is a New York Court of Appeals case. Loxon's statements here were directed only to Buono and other on the hospital staff. They weren't like Yelp reviews. They weren't like reviews posted for the benefit of other consumers or patients.
About a separate issue, which is the claim that you can't go forward with this because you didn't bring a counterclaim or a separate action or proceeding as required by the statute. What's your response?
The real thorn for my client is the res judicata issue here, that the lower court has ruled that this is not an anti-SLAPP motion. So this court can rule in 4 ways, I believe. First, you could uphold the lower court's ruling in full. That's a problem for my client because of res judicata. Second, you could reverse the lower court's ruling on the anti-SLAPP issue, but instead of remanding to the lower court, you could say there has to be a plenary action. I don't think that that's appropriate for the reasons we brought up in the reply brief. This is a claim. The third thing you could do is remand to the lower court for a jury trial on the issue of the amount of punitive damages, if any, to be awarded to my client, and remand for inquest to determine the amount of attorney fees to be awarded to my client. And the fourth thing you could do is remand for a jury trial on the very issue of whether this is an anti-SLAPP case to begin with, because Judge Kotler ruled that this is not anti-SLAPP as a matter of law.
I'm going to let you respond in your rebuttal time, but I don't think that's for a jury, whether it's anti-SLAPP. I think we have to decide that. But let me hear from opposing counsel.
Good afternoon, and may it please the court. Logan Rappaport for respondents. Your Honors, the trial court correctly held that this was not within the ambit of the revised anti-SLAPP law. Basically, what appellant's requesting here is for the court to issue a ruling that is sweeping and unprecedented in nature, that would sweep up essentially every online review.
Wasn't there just a recent amendment to the anti-SLAPP statute, which has made it extremely broad, the language, as to basically any dispute, and the legislative history also makes it very clear that the statute is to be read in an extremely broad fashion. Based on this change in the law and the legislative history, why would this case not fall under the statute?
Because I believe that the requirement here that for broad interpretation of what constitutes an issue of public interest is for, in order to avoid those close calls where you're touching upon something, say, that may potentially be regarding a public controversy, but it's not exactly crystal clear. The purpose of the law is to protect and enhance public debate about matters of public controversy. It's not to protect purely private matters that involve...
Why wouldn't other people be interested in someone's comments about a doctor so that they could make their own informed decision about whether they want to go to that doctor? Why is that not a matter of public interest?
Well, if the New York anti-SLAPP law, even though there has been very few cases and certainly no binding control, other states have had a similar law with similar phrasing of what constitutes a purely private interest, what constitutes an issue of public interest, have dealt squarely with that issue, including with respect to medical reviews, where it is a single transaction regarding whether the patient or consumer, as the case may be, liked or did not like this specific services, or the way in which services were provided, or in this case about the communications of whether a fiance was banned. That is a private commercial dispute. Now, it's certainly of the benefit, some people might be looking to utilize the services of my specific client, but it doesn't touch upon a broader public debate, public controversy, or I think in one case that's widely cited out of California, I think it was the Yang case, it involved certain reviews regarding a dentist. And the dentist and the reviews in question did not, and the court said as much, that it wasn't that it didn't become a matter of public interest because the dentist, performs, makes available his services for, a large amount of the public. It's the fact that those reviews in question touched upon the use of certain mercury and silver amalgam, things that had been in the public eye that had generated public debate. It can't simply be, and this tracks with New York law and the Second Circuit interpreting, what is a private controversy. It can't be a single commercial transaction and a complaint regarding a single commercial transaction unless it touches upon...
Aren't we demeaning a little bit the relationship between doctor and patient when we refer to this as a commercial transaction?
This is a performance of services that is widely available in the marketplace. So, I may be being a little loose referring to it as commercial, but it does not, the criticism here wasn't the kind of procedure performed. This wasn't a controversial procedure that has stimulated wider debate. It wasn't, there was no allegations of some sort of pattern or practice on the, by the doctor or his office.
I'm just confused why other patients wouldn't be extremely interested in the allegation that the services provided were inadequate. I mean, why is that not of interest to others other than just this plaintiff and this defendant?
Well, that could be said for every single potential review. I mean, if not just.
I think the statute is worded extremely broadly, communication in a place open to public or a public forum in connection with an issue of public interest. That's a very broad language. And public interest shall be construed broadly and shall mean any subject other than a purely private matter. That's expansive language.
It is very expansive, but it still has to be a matter of public interest. And I think the second department in the Peekskill Star case had defined it that it has received public attention because its ramifications will be felt by persons who are not direct participants. Here it was just the services with respect to this one transaction.
Thank you very much.
Your Honor, no other states, nor the model anti-SLAPP law, use the exact language that's in this statute. This statute is broader than anything out there that I've seen. The plain language of the statute reads that this is an anti-SLAPP law. To address the issue of the plenary action, once again, this was a comprehensive statute designed to reduce the burden on defendants for anti-SLAPP lawsuits. So requiring those defendants to bring a second suit, a second action in order to claim attorney's fees and punitive damages would just add additional work.
Sir, I'm sorry, your 3211 motion, was that pre-answer?
It's a pre-answer 3211
So you
motion.
haven't interposed an answer yet?
Right, and so my point is that the whole scheme, including 3211G, is designed to encourage pre-answer motions. It actually blocks discovery while those motions are pending. That overrides some local court rules, such as in Westchester. So I want to address the other question about demeaning the doctor-patient relationship. The words here are purely private, so even if there's a commercial aspect of the relationship and a non-commercial aspect of the relationship, and there's admittedly a huge, private aspect to doctor-patient relationships, there's still market participants in the market for healthcare services. And so, yes, people outside of the, a very narrow, small, private group would be interested in reviews of the business as a practice, just like a law practice can also be a business. Again, the key word here is purely. If it's only a private matter, I think that's synonymous, then you uphold the lower court's ruling. If it's not only a private matter, then don't uphold the lower court's ruling, remand in some way. And we think the best way is for it to be as a matter of law that this is an anti-SLAPP suit under the plain language of the statute.
Sir, what about your friend's point that this was an isolated matter? This was not a repetitive, ongoing issue with this patient and this doctor?
I'm sorry about my, the point that I was trying to make is that this patient had a number of posts that were made about the doctor. So there were ongoing issues with the doctor. I think there were multiple surgeries that this patient had with the doctor, and it addresses some of the issues that were brought up in multiple dealings, multiple interactions with the business and the doctor. So it goes to the ongoing relationship of the patient and the doctor with regards to bedside manner, follow-up care, things like that. It's not just the surgery or the pre-surgery consult, it's the post-surgery care as well.
Any other questions? Okay, thank you very much.